Good morning, everyone. Today we're going to discuss when do solo agers need a revocable trust. So sometimes a revocable trust makes great sense for a solo ager estate plan. Generally, revocable trusts aren't so great in New York because they can be very hard to fully and correctly fund, and therefore you basically don't even avoid probate, which is usually the main goal of a revocable trust. So here are a few reasons why a revocable trust may nonetheless work well for a solo ager. So first situation is solo agers tend to have distant or sometimes disinherited heirs. When you are a solo ager, just by revisiting the definition, you're usually unmarried and either don't have kids or they're, sort of not in the picture. So then you're naturally in a situation where you have non-nuclear heirs, which I guess you can call them distant, either nephews, nieces, siblings, and so forth. So, for example, we had a recent client whose sole natural heir, was a distant cousin. So in this case, a trust would make a lot of sense to help avoid the probate process because when a remaining heir is a first cousin, you have a lot of extra hurdles during the court process. You have to do a genealogy report. You have to hire a genealogist and submit that and have the court approve it. You have to have the public administrator, basically a court entity, involved, reviewing and, with court dates. And it just generally makes probate longer and more difficult. Now, let me make something clear. This is not necessarily only if you are leaving something to that distant heir, but rather the probate court process requires you to notify whoever your natural heirs are, meaning your default heirs under New York state law, which would include, in this case, your distant cousin. So it's not even if you decided you didn't want to leave anything to this heir or to this distant cousin, you still need to go through this process if you go through the probate courts. Similarly, if you have a disinherited family member, when you go through the probate court process, that's when they have an opportunity to object to your will or your plan. When you go through a trust, they still have that opportunity, but it's not as structured. It's not as laid out for them. When you go through probate, you have to send them a notice. You have to serve them actually with a notice saying, here's the will that we're proposing. Let us know if you'd like to object. And if somebody's been disinherited, they're, more likely than not to say, hey, I have a problem with this. Whereas with a trust, you don't have that sort of structure. You're not required to send notice. And, unless they do some digging on their own, they may not actually object. But as I mentioned before, you must fully fund your trust in order to avoid these problems. So what I mean by that is, let's say you have an apartment, a couple bank accounts, and a couple brokerage accounts. If you miss any one of those things, let's say the apartment is not able to get into the trust for whatever reason, then although the bank accounts and brokerage accounts avoid probate, you still have to do probate and do everything we described above for the apartment. So, if the goal is to avoid a genealogist and, the court process, you still have to do it. And same with if you're trying to avoid a disinherited heir causing a problem or an objection, if even one account goes through there, then, or one asset goes through probate, then the same problem persists. That's why it's so important to fully fund your trust. Okay, hope that makes sense. So another reason why revocable trusts may make more sense for a solo ager in New York as opposed to non-solo agers is because a revocable trust is actually very useful in lieu of guardianship. We've talked about guardianship before in episode 208. We'll throw a link in there. So here's how it works. By putting your assets into a trust, it helps you to avoid or maybe even deter the dreaded court-appointed stranger, which we've talked about at length. Again, we'll throw in a link for that. So what that means is you can imagine, or actually maybe you can't imagine, but unfortunately, there are situations where these court-appointed strangers, these guardians, and I want to give them the benefit of the doubt. I wouldn't say they prey on solo agers, but the incentives are that those are cases where they can sort of insert themselves. They can sort of impose themselves on somebody who's maybe doesn't have family members nearby to advocate for them, and say, hey, yes, this person is not competent, even though he or she may be, and sort of nudge that along and kind of push it through the court until they're appointed to have control of your assets. It's a very scary proposition. You should watch the movie I Care a Lot on Netflix. It's very dramatized, but it does give a good sort of breakdown of how something like this could possibly happen in a very frightening and Hollywood kind of way. So how does a revocable trust avoid this court-appointed guardian? Well, if all of your assets are in a trust and the trust is done, reasonably properly, if you're determined to be incompetent, even if a court-appointed stranger, pushes your situation to the courts and gets a judge to somehow say that you're incompetent, they don't get the appointment. They don't get control of your assets. It just goes to whoever you named as your trustee. So there's very little incentive for them to put in this work to try to get you named or adjudicated to be incompetent, because there's no payoff for them. So that's why it's a deterrent, and it helps you avoid the court-appointed stranger problem. And in this situation, partial funding is okay. For this goal, partial funding is decent. If you're able to get the vast majority of your assets into the trust, even if you miss one or two, as long as the amounts that are left or that don't make it into the trust are nominal, or not enough, I guess you would say meat on the bone, not enough of a target for a court-appointed stranger, then you should be fine. Because again, it's a lot of work for them to it's a lot of work for them to get you appointed or judged to be incompetent. So to make it worth their while, there has to be a big estate for them to come after. I know this is all very cynical, but unfortunately it does happen. All right, so lastly, the last reason why a revocable trust may make sense for solo agers is for end-of-life planning, maybe. So what that means is, there are situations where, unfortunately, whether it's because typically because you're terminally ill, you sort of know that the end is near. I don't know how else to put it. And this makes planning much easier than if you're in your middle age or otherwise, because you know what your assets will be upon your passing, instead of bank accounts changing, moving houses, buying, selling houses. You kind of know exactly what you're dealing with. Because if you live another 15, 20 years, 30, 40 years, whatever, your assets are definitely going to change. So having a known set of assets really makes planning much easier. And knowing the actual date of death, or sort of a target range, not really a target, but really makes it less likely that you'll miss something during the funding process. So if you have that situation, which is not great, obviously, but it does make planning a bit easier. That being said, we have done, we've helped clients in this situation, and people still miss stuff. It's just really hard to put a bow on it and wrap up everything in your life, all your assets, to capture everything, even if you know the exact date and time when you're going to pass away. So for that reason, you may not want to spend all your time planning, thinking that, if I spend enough time, I'll get it 100% right. It still doesn't work out that way, at least in our experience. And also, if you're not well, and if you only have a certain amount of time left in this world, really, would you want to spend it planning? That's my personal take. I wouldn't spend that much time planning your, final funding to make sure my trust is fully funded. Enjoy your last time to the extent possible. All right. So that's it. So again, typically revocable trusts don't make a lot of sense in most situations in New York, but they do for solo agers for the reasons that we described above. If you want to learn more, make sure you check out my book, The Solo Ager Estate Plan. It's on Amazon, and actually, if you fill out the form below, we'll be happy to send you a free copy. Very helpful stuff to help you understand some of the issues that are specific to solo agers. Thanks, everyone, for listening. Let me know if you have any questions in the comments, or email us, and we'll talk next time. Take care.